Okay, we're set.
Yep. You're
Right.
good.
Oh, I see it at the top.
We're ready to roll. Well, good evening, ladies and gentlemen. Welcome to the February 17th, 2021 meeting of the Danbury Planning Commission. We will open with the roll call. Mr. Urice.
Here.
Ms. Hostetter.
Here.
Mr. Kiokio.
Here.
Mr. Sylvain.
Here.
Mr. Renz and Mr. Haas are absent. Chairman Finaldi is here. Okay, we do not have to seat any alternates this evening. Again, I'll make my standard introduction. This meeting of the Danbury Planning Commission is being held on Zoom as a virtual meeting. Even though this meeting is a virtual meeting, members of the public and interested parties continue to have the opportunity to participate in the meeting in a couple of different ways. You can participate via Zoom and see the audio and the video, or you can call in by phone and participate via audio only. Just a heads up, if you call in, we may have to ask you to mute your phone to avoid an echo. Instructions on how to participate in the meeting appear on the City of Danbury website, and all of the documents and materials that apply to the matters to be discussed during this meeting, including the agenda, are also available on the City of Danbury website. As always, if you have any questions, please contact the City of Danbury Planning and Zoning Department. As a reminder, the entire meeting will be posted on and can be seen on the City of Danbury website. We will follow the posted agenda as per standard practice. If prior to the meeting, any questions or comments on agenda items were submitted via email to Sharon Calitro, those comments will be read during the appropriate portion of the meeting. One other thing, commission members, I'm not going to necessarily take a roll call vote for everything we do, because that gets kind of tedious. If it's a approval or a denial of an application, we will definitely take a roll call vote. But for things like accepting the minutes or adjourning the meeting, for that matter, we'll just take a voice vote. I think we'll be okay with that. It'll speed things up and again, be less tedious. Okay, looking at the agenda. The minutes of the February 3rd, 2021 meeting were previously distributed to the commission. Unless there's any corrections or comments on those minutes, I will accept a motion to accept them.
So moved.
Second.
A motion has been made and seconded to accept the minutes of the February 3rd, 2021 meeting. Is there any discussion? On this matter, I will take a voice vote. All in favor of accepting the minutes, say aye.
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 Opposed? The minutes are accepted. Let the record show our next regular meeting is scheduled for March 3rd, 2021. This evening, we have no public hearings, so we will move straight to our continuation of public hearings agenda. Jen, should I first announce that the matter of Newtown Road is being tabled? No, should I do that first, or should I just go right to JAR?
You can go right. Well, I
don't know
don't
if
have the agenda in front of me. What's the first item?
JAR is first. So let me do this.
Yeah, do JAR first, and then we'll do because I don't see anybody from the
Okay.
public.
Let me just make a general announcement. The matter of Newtown Road LLC, Maria Emanuel Andre, et cetera, will be tabled tonight. We will officially table it in a few minutes. But I just wanted, just in case anyone was on for that particular matter, again, it will be tabled and we won't be hearing any testimony on that particular matter this evening. Okay, with that said, we'll move right to continuation of public hearings. Item 1, JAR Associates LLC, D&B Wellness LLC, application for special exception. Revised site plan approval for a medical marijuana dispensing facility in the CA80 zone, 105 Mill Plain Road, C14063, special exception 779. Previously distributed were updated responses from the applicant. Submitted on 1/26/21, updated site plan revised through 1/25/21, and an updated staff reports which were received on 2/16/21. Is there anyone wishing to speak in favor of this application?
Mr. Chairman, if I may, Neil Marcus, Kona Wolf PC, on behalf of the applicants, which are D&B Wellness and JAR Associates as tenant and owner respectively.
Just 1 second, Neil, 1 second. I'm getting an echo, so if somebody can mute, if you're on a phone, or if you can mute yourself if you're not going to talk. I'm getting a bit of an echo. My apologies, Neil. Go right ahead.
That's okay. I hear it too. He always said.
Okay, so Joe, let me just interject for a second. Did you X out of when you live streamed it on YouTube? Did you X out of that window? Because that could be causing it.
I didn't think, oh, wait, that's it. It's me. Okay, hold on.
Just X out of it. It'll, oh, there you go.
I
That's
forgot. Okay.
That's
here we
okay.
go.
I think we're good to go.
Excellent. Thank you, Mr. Chairman. At the end of the last session, we had a number of outstanding requests for to meet some of the city staff reviews, various departments. And at this point, since I have our architect, Steve Hammock, on the screen, I think I'll ask him to start off and just run through what changes the commission should be aware of from our last meeting, if he could just highlight them. Steve? Unmute yourself.
Okay, yes.
Thank you.
Shall I share my screen or to view the site plan, or should I just go through them? Excuse me, I'm Stephen Hambrecht. I'm the architect for DB Wellness.
What's easier for the commission? Would you like us to put up I think, Steve, it would make sense to put up a site plan, show them what changes have been made, if you can do it.
All right, somebody needs to give me permission to share my screen.
Joe, you got to do that.
Yeah, it says one participant can share at a time. Is that what I want?
No, go to multiple.
Oh, multiple. Okay. Hold on.
You know, by the time we get
Okay, I
this
got it.
down to a science, Arnie, the pandemic will be over.
Okay.
So true, so true.
Okay, can everybody see the screen? This is the revised site plan submitted in January, and this addressed, I did discuss this briefly at the last meeting that we attended, but this addressed the initial comments and the subsequent comments from staff report and the engineer and so forth. So this site plan represents just the proper site plan, not the church property at the rear of the site. We addressed some issues regarding providing a sidewalk, the sidewalk across the entire property of 105 Mill Plain Road. We addressed that. Other comments were identifying the sewer and water lines within the street accurately based on the engineer's comments. As you can see, we've shown that. We've also illuminated the fact that the curb is being removed, the drive-through canopy is being removed. Those were comments that were also provided by the town. We also angled the parking space for the accessible parking space, and we've shown the proper type of symbol for the accessibility. We are at 16 spaces. The requirement based on our calculation is 15 plus 1. We are at 16 plus 1. As you can see, the calculations over here, based on the square footage, we are at 15 parking spaces as a requirement plus 1 handicapped space. We're at 16 at this point with this plan. We also, some of the other highlights are we relocated the trash and recycling and labeled them accordingly as per some of the comments from the staff report. We identified the loading zone, and we also provided the existing 6-inch the dry wells, and then the type of PVC piping for the dry wells and cleaning out of the dry wells as a maintenance item. So those were some of the highlights of the changes that were made that are on the site plan here.
Questions from Hambrick?
Yes.
Any questions, commission members, at this time? No, I don't hear any questions.
Chairman, I have a question.
I'm sorry. Let me go ahead. I'm sorry. Is that Perry? Sorry.
Yes, yes.
Go ahead.
I know at one point Abdul's comments were hopeful that they could change it to a three parallel spots where those angled parking spots were. And I know without that second lot, perhaps you need those spots. But I was just curious where, and maybe this is more a question for the department, but I'm just curious where we stand with that particular comment of Abdul's.
Mr. Chairman, if I may.
Go ahead, Jen.
As you saw from Abdul's final staff report from yesterday, and I included that with the agenda, he was satisfied with those parking spaces.
Okay, I must have missed that. I'm sorry.
Yeah, no, it's fine. That was one of his initial comments. And again, he had requested a different type of circulation, so the parallel spaces worked under that scenario, but given the one-way ingress and then the egress, the parallel spaces didn't really make sense. So the 45-degree angle tends to work better with the one-way ingress.
Okay, thank you.
Any other questions at this time for Mr. Hambrick?
Mr. Chairman,
Please, Joel.
a couple of questions and some lingering ones from before. With the relocation of the recycle and regular trash bins to the back of the parking area, is there sufficient distance between that trash location and the pickup trucks to be able to come in, and I guess they probably are forklift type things?
Before you answer that question, I'm getting an echo again. I don't know where it's coming from. I imagine other people hear it too.
Yeah.
So if you're not speaking, if possible, mute your microphone and then, of course, unmute when you wish to speak. If maybe that'll do it. I'm sorry, Joel. Go ahead.
Okay. Back where you have trash and recycle canister containers, I guess they are. Is there room in that is sufficiently to have a pickup vehicle come in with its fork front end and pick those things up and dump them in the truck? Question for the architect.
Yes. Well, we've been discussing that with the DB Wellness team, and we're planning on having a rear pickup for the trash and recycle. So the idea is that the garbage vehicle comes in this way and then backs up to the trash and recycle, picks it up, and then goes out.
Okay. Could
The
you
egress.
point out with your arrows again? I didn't
sorry.
see it moving around where you were going to move.
Okay, so the vehicles come through the site and the egress location at the front of the entrance of the property.
Yep.
They come down, they circle around the back of the property, they back into the trash and recycle area in the loading zone to remove the trash and recycling, and then they leave through the egress portion of the property through the front. That is the current plan.
Okay, so they're going to manually transfer the trash into the pickup trucks? If they're backing in, I'm not aware of any trucks around town that have, if you will, lifts on the back for anything other than a small trash can.
Well, actually, Joel, if I can try that at Steel Marcus, some of the trucks, they have all sorts of different designs, the side lifts, the front lifts, but they do have trucks, for example, that come in and pick up a receptacle from the back end, dump it in and drop it down. Yeah, we leave that up to the trash companies to figure out how to do it.
We need to be sure that the trash company can actually do that.
Yeah. No, the guys that we deal with over at Oak Ridge have a whole fleet of actually different types of trucks for different types of stops.
I'm quite familiar with them. I'm attend all the HRRA meetings, but I just can't recall ever seeing a container retrieval from the rear of any of
Oh,
the.
there is, if I could interject, there actually are, there's like, Neil says, front end loaders, rear end loaders, and side loaders. And I've seen rear end loaders that back up to what we would call a dumpster or a container, 4 yard, 2, 3 or 3, 4 yard container, hook it, dump it into the back of the truck and then let it go. No, they're out there. I've seen it.
Yeah.
They used to do that over at our building when I was on Main Street. That's how we did it over there.
Satisfies that question. There was early on some discussion from the applicant that certain special exceptions that had been given to a prior, or if you will, variances that had been granted under a prior special exception was going to play into this design. And of course, I don't really need to remind everybody, if you have another special exception, any variances from the old one go away. So is there any reliance on any variance that was granted in a prior special exception?
To my knowledge, Joel, no. But again, I would defer to staff on this if they think that there are any missing or needed variances or no. I mean, the answer to the best of my knowledge is we have a conforming site.
If I may, Mr. Chairman,
Go ahead, Joel.
ask staff if they're aware of any requirements that are not met by the independent design of this special exception.
Mr. Chairman,
Go ahead, Jen.
when it was Webster, it was Village Trust, I believe, and then it became Webster Bank. That's an old site plan. I don't know the number off the top of my head, but it is not a special exception. It was an old site plan.
Exactly.
And at the time, the aisle width was at, I believe it was 20 feet, and that has since increased to 24 feet. So, that's an element that's pre-existing non-conforming that carries over from the previously approved site plan. There are no variances that I'm aware of. They weren't noted on the A2 survey. So, and again, if they needed a variance, we certainly, we would have stopped this process, quite a while ago to make sure that those variances were in hand. I'm not aware, again, going through the regulations and compliance with the site plan, it does comply with the regulations.
Okay, thank you. That's it. Oh, there's one other. With all the little changes and such, did you change at all the handicap access from the rear of the building that had been discussed in a prior meeting?
No, the handicap access is from the front of the building. There is no viable handicap access from the rear of the building. So it's all from the front.
Okay, so they have to go in the front of the building and
That's right. That's why they,
all the way to the back, then to the elevator?
no, well, no, the public is operating on the first floor of the building. So there's a handicap accessible spot near the front of the building, which is the closest spot to the accessible entrance to the building. And then the public, who are the people who will be parking in these spaces, have access to the entire first floor, which is entirely accessible with an accessible toilet, so forth. So the handicap accessible entrance is on the front, which is adjacent nearby to the accessible parking space. So that's where they come in.
All well and good for the public. How about the employees that are working on the floor below or above, whichever it is?
Well, I would say that there are there are offices on the lower level, and there are offices on the main level. So there are opportunities for employees who are disabled to work on the main floor of the space without having to go down into the basement. So there's offices and office functions and behind the scenes functions and that are maintained on both levels and then also the second floor, which is a space that is being used for office space and storage space.
Okay, can you categorically state that no handicapped person would have their, if you will, career path hindered by not being able to go to one of the other floors?
Well, what I can state is that we're certainly meeting all of the state regulations and guidelines as they relate to handicap accessibility for the customers and the employees. So that means that there are opportunities for employees to work and operate on the first floor as there are on the basement. So whatever regulations are applicable in the state of Connecticut, we are absolutely adhering to those 100%.
Mr. Chairman,
Yes, Joel.
I'd like staff's opinion on that statement.
Mr. Chairman.
Go ahead, Jen.
So at this point, we've had a review from the building department, the actual building inspector, Dave Newland, did a review with respect to compliance with the ADA requirements for the handicap parking space and access into the building. Once the applicant applies for the necessary building permits, the building inspector will then do a review for the internal layout of the building for ADA compliance. That does not happen at this stage of the application process. It happens during the permit review process. It's a completely separate review, and they are in fact reviewing for ADA compliance for inside the building.
Okay, thank you.
And Joel, this is Carl Torella, manager of the building. I'm just gonna, 7 Forest Ridge Road, sorry, Nyack, New York. As the manager of the building, I can categorically state just that no one of my employees will, careers path will be hindered by not having an access of the elevator. All the functions can be done on the first floor in terms of anything that needs to be done with inside the building from an employee perspective. So I just want you to be aware of that as well.
Okay, yeah, that just made it part of the record. Thank you very much.
Sure.
Commission members, any other questions for Mr. Hambrick at this time? Hearing none. Attorney Marcus, anything else?
Yes, sir. We, again, Ralph Gallagher has submitted responses to the engineering department. And I believe at this point, we've got a sign off from engineering on the work that's proposed. So I'm not sure that we're going to hear any presentation from Ralph this evening. I'm not even sure if Ralph has joined us on the call.
No, Ralph was unable to join us.
I thought he had a conflict, but
Yeah.
again, Steve would try to answer any questions that you might have, but I'm not sure there should be anything from engineering at this point. The other issue that I'd like to, Carl Torella was on a second ago. There was some question, as you know, from the failure to provide I'll call it the church parking at the back of the property, which we thought was available to us. And Tony Rizzo, I know, was on the Zoom, and he'll be back to address this as well. But we are committed to providing additional parking for the staff, because even though we meet the minimum zoning reg, we want additional parking so that we have more than just the minimum requirement. Jennifer and I have had some discussions about this, and I think that there may be some misunderstanding as to what is required for employee parking. Carl was quick to answer the question, how many employees do you have? Well, we have 15, but I'd like Carl to tell us a little bit about how many employees are actually in the building at one time, so that you have an idea of the additional off-site parking that we're going to provide. Carl, can you comment on that?
Sure. Thanks, Neil. So obviously, we do have 15 to 16 employees on our staff. At any given time, there can be up to 7 to 8 employees inside the building in terms of operating the facility. Today, we had 6. I mean, obviously, it can go up to 8 on the demand hours. So that's what we expect from an on-site employee workflow perspective. So it's not actually the 15 that I quoted, rather that was the whole staff. It's actually 6 to 8 on time on site at any given time.
Thank you. And now I see Tony's back on the screen. Maybe he'll unmute himself if he wants to chime in. But Tony Rizzo and I have had a lot of discussions about where he stands in acquiring the parking lot that he built on the cemetery that he maintains. And the only thing I don't know about this is whether he has claims any relatives to be buried there. I don't think so.
Just
But,
myself when the time comes.
but the fact of the matter is that he's in contact with the church that used to be up on Madison Avenue. The last time I had a dealing with him on that parking lot, he's been in contact with them, and it's my understanding. And Tony, tell me, and I've provided the correspondence via email to Jennifer for her record on this. It's my understanding that tomorrow the church will have its quarterly meeting, and on the agenda is approving the sale of that parking lot to JAR. They have a deed already in their possession. Tom Beecher has the money that's been offered to purchase it. And we expect that tomorrow Tony will get the nod that he's going to be able to buy this, which is a huge relief for all of us, because it'll provide, at the moment, off-site parking until we can include it within the site. But that parking is still available to us based on conversations that Tony has had with church, that they don't object to him parking there today, nor have they in the last 30 years almost since that parking lot was actually built, thinking that it was part of the original purchase.
Closer to 40.
Just to interject for 1
40,
second,
right.
folks, if I could, I'm getting that echo again. I don't know where it's coming from. Again, the only thing I can think of is mute yourself unless you're speaking, and hopefully that'll go away. So let's try that. It's just a little annoying. We can still hear, but it's a little annoying. So let's give that a shot. Sorry, Neil, go ahead.
Okay,
And I'm sorry, Mr.
just,
Chairman, Tony, I'm sorry, hold on. Tony, if you're going to speak, you need to state your name for the record.
unmute.
Okay.
Mr. Chairman,
Thank you.
is regarding the off-site parking, as long as the site plan is in accordance with the requirements, whether you provide your employee parking in the church property and buy that, or you make some arrangements down the street with Stop and Shop, but it doesn't really impact this approval process. I don't believe, because you're talking about parking places that aren't required in the regulations. So,
No, I agree, Joel, but I think Mr. Rizzo wanted to say something on that subject. So despite the fact that I agree with you, if there's something that you wanted to add, Tony, just state your name and address for the record and go right ahead.
Yeah, it's Tony Rizzo Jr. I'm the managing member of JAR Associates LLC at 64 Triangle Street in Danbury, Connecticut. I just wanted to state the property that we're talking about that is church property was apparently a misunderstanding way back when we received the deed for an initial parcel that we took over. That parking lot was built close to 40 years ago in the back of the building. It's been used from the time it was Union Trust Bank to New Mill Bank to Webster Bank. The parking has been there. We've maintained the parking area as well as the cemetery itself, as far as mowing and any type of maintenance that goes with it. We did track down the people from Eastern Regional Association out of New Hampshire, and I've been talking to Reverend Gregory Twitchell. He has given me communication that the parking that we have been utilizing a lot, we feel free to continue to use it. As to be honest with you, they didn't even know they had property in Danbury until he did a Google search when I gave him the address, and he did a shot that way. He has a meeting tomorrow with the board. He's had conversations with the board of directors. It all appears in good standing that they'll vote in favor of the transition and deeding over that last small piece of the property that will take us right up to the cemetery. So basically what's there now, unfortunately, they only meet once a quarter. Tomorrow happens to be that meeting tomorrow morning, and he anticipates having an answer for us in the afternoon. And in the meantime, he said to continue doing whatever it is we're doing because nobody has any access to that lot anyway, other than coming through our parking lot, which they have an easement to travel through now to get to the cemetery. So that's what I wanted to share with you.
Yeah, you actually probably have a good case for ownership by adverse possession.
That's, Joel, I got to tell you that I agree with both of your observations. A, that if in reality, JAR actually does own that, subject to quieting the title, but I believe that we're going to have this resolved tomorrow. I happen to agree with you that the issue of the employee parking is really just Carl Torella's management issue. He's got to provide employee parking. Interestingly enough, I've talked to a number of the property owners. Eddie Batista, who's got a piece across the street, said that if there's a pinch and they need parking, and he'll help out. I mean, while recognizing that Tony will acquire the piece that ultimately has to be melded into the site plan, but that will be a new application at the point that we actually have the status to file it. So I just wanted you to know that employee parking will not be an issue at all.
I didn't think it was.
Thank you. At this point, I'm not sure that there are any issues that were left up in the air unless the commission has any questions or staff, Jennifer. But we
Any questions? Go
Mr.
ahead.
Chairman?
Yeah.
Neil, I need you to go through and talk about Abdul's staff report as well as your response letter to that. And just for the record, early this afternoon, I transmitted to the Planning Commission a copy of your letter dated, I think it was yesterday afternoon that came in. I forwarded that to the commission, as well as an email chain from Councilman Paul Bertello to Abdul with a copy to Sharon and then a copy to me. I've included that as well as, again, Abdul's staff report. So if you can spend a few minutes talking about your letter and how that relates to Abdul's comments.
Okay, I will tell you in 1 second. I'm going to pull that up on my other screen here. Give me 1 minute. Okay, so we have agreed with most of Abdul's comments dealing with our site. We will extend a sidewalk in front of the site as he's requested, and the sidewalk will be ADA designed in terms of meeting their requirements. That's fine. Then Abdul goes on to a couple of other off-site issues. He would like a sidewalk on the south side of Mill Plain Road. And that is, we will not agree to do that. And quite honestly, he really can't ask us to do that. That violates the rule that was laid down in the buttermilk decision, which says that a town cannot, they call those exactions, where a town says, well, if you want to get a permit for your site, you got to go do work off-site. And that's an exaction, and they're not legal. But I'm not sure why Abdul is doing that, because the piece across the street is in fact owned by Eddie Batista. And this commission has had in front of it over the years a number of site plans for the development of the Batista property, and all of those required the sidewalk that Abdul is talking about. So that would be more appropriate to ask the owner across the street, in this case, Ed Batista, to put a sidewalk in front of his property. That's kind of how we normally do it. So I'm just not sure, but that would be an added expense and burden to this site, which wouldn't be warranted by any of the traffic information that we've given to you and the testimony from our own public in terms of how they use this site, that in fact, we had only one person who said that they might walk down from Rivington, and then they have to cross Mill Plain Road. They can cross Mill Plain Road. Much to Jennifer's surprise, there is a walk light there. And by the way, much to my surprise, there's a walk light there because this walk light just appears in the middle of nowhere, literally. And that was another of Abdul's claims. There's a walk light that's been there for, I don't know, 10, 20 years, who knows? But it's not connected by a sidewalk in front of the Ryer building, nor a sidewalk in front of the Batista property. So basically, you have to walk in the shoulder of the road or on the grass. I did it myself. I walked in the snow. I went over, I punched the walk light to see if it works, and it does. That walk light controls the traffic light in Ridgeberry Road. And if you punch it, it'll stop traffic and you can cross Mill Plain. There's no crosswalk there, but you can actually walk across without people running you over and taking that risk. Except for the people who wanted to take the right-hand turn on Red coming out of Ridgeberry, they didn't seem to pay too much attention. But then again, they're just used to a right on Red. But in reality, when it goes into the walk cycle, they're not supposed to do that. So that's there if somebody really wants to access the property from the south side of Mill Plain. But there's no indication that that's going to be a reality, and that sidewalk is the need for the sidewalk is generated by this special exception or site plan. So on that one, we have objected to Abdul's request, and we're going to ask that you hold that request. And don't tell Ed Batista that I said this, but you hold that request until we bring the next site plan back for Ed Batista. Because in reality, he did plan a sidewalk there when he went in with a convenience store a number of years ago. So on that issue, and then of course, Abdul wants this applicant to upgrade the walk light. And that is owned by the state of Connecticut to the best of our knowledge. And I'm just not sure that, again, it's the city's prerogative to try to tell the state that their walk light isn't satisfactory to our engineering department. But the walk light works. It's old, you punch it, it goes on. Abdul would theoretically like us to put in a larger button, the more modern button with a bigger sign on it. And if the state does require that as part of our state work, then obviously we're going to have to do it for the state. But to make it a condition of this approval, we think is again a reach, and we would object. That walk light appears to have operated fine for all these years. And I bet you that you can probably count on one hand the number of people who use it in the course of a year, because nobody seems to know it's there. And it certainly wasn't put in a place that was to attract pedestrian traffic. And at that point, I would suggest that that's our problem. And I'm not sure why Abdul wants this, but if he feels it's necessary, I think he really has to take it up with the state DOT, because all of this work is really state highway work, the sidewalk included. On our side of the road, we're going to do everything he's asked us to do. And that's kind of where we are. Does that explain where we are?
Yeah.
Did I miss anything? That was my letter back to
Mr.
staff.
Chairman,
Sure.
I'm not aware that anybody on the commission is even considering requiring anything other than what's runs in front of the property. So
Thank you.
No, I agree.
we
And
talked all week and heard all we need to hear about that topic.
Thank you.
Yeah, I will just add quickly that I did see that correspondence, and I agree with the letter from Cohen and Wolf, the letter from Neil Marcus dated February 14th. I just don't think those offsite improvements are necessary. Well, first of all, we're talking about converting a building that was a bank into a medical marijuana dispensary. You know, it's not a Starbucks, it's not a convenience store, it's not a restaurant. I don't anticipate this is going to generate a lot of foot traffic or pedestrian traffic. And secondly, if it did, where would these people come from? Like, who's going to walk to this place? I just can't imagine anyone up at Larson Drive or Briar Ridge, you know, walking down past MCAA and walking down past the Crown Plaza Hotel, going over the bridge over 84 down the hill on Old Ridgebury Road, walking across a very dangerous intersection, busy intersection, to a medical marijuana facility. I just don't think they're going to do it. I just don't think I just don't anticipate a lot of foot traffic because there's no residential close by. And then third, as a practical matter, I mean, again, this is a state road. You're talking about moving utility poles. You're talking about getting state approval. I just thought it was much ado about nothing. So I agree with what we just heard. If one person called and said they want to walk there, I would tell them to drive because you know, I'm not sure it's the greatest place in the world for pedestrians. So that's how
Thank you.
anything else, Attorney Marcus?
That's it for us. The applicant will rest in the hopes that we can move this along quickly at this point, because the applicant serves a community that really needs a better facility. So we'd like to move on. Thank you.
Got it. Thank you. Is there anyone else wishing to speak in favor of this application? Anyone else in favor? Anyone else wishing to speak in favor of this application? Is there anyone wishing to speak in opposition to this application? And anyone in opposition? Is there anyone wishing to speak in opposition to this application? Any other comments? Jen from staff?
No, I've reviewed the revisions. Everything complies with the zoning regulations, and we've received sign-offs from the building department, the fire marshal, construction services deferred to the state with respect to improvements, and absent, you know, Abdul's comments, which the commission has already discussed, staff has nothing else to offer. And if it's up to the commission, you're ready to close if the commission chooses to.
Mr. Chairman?
Go ahead, Joel.
In light of that, I'd like to make a motion to close the public hearing.
Motion made to close the public hearing. Do I hear a second? Harry Sylvain, second. Motion made and seconded to close the public hearing. On this one, I will take a roll call vote. A yes is to close and no is not to close. Mr. Urice.
Yes.
Ms. Hofstadter.
Unmute.
Oh, yes. Yes. Yes.
Yes.
Is that Ellen? Okay, thank you. Mr. Kyokyo.
Yes.
Mr. Sylvain.
Yes.
Chairman Finaldi votes yes. This public hearing is closed. Thank you very much, ladies and gentlemen, for that one.
Thank you.
Okay, we're going to keep moving right on.
Mr. Chairman, I'm sorry, can someone make a motion to move this for possible discussion?
So moved.
I'm sorry, who made that motion?
Joel,
Thank you.
do I hear a second to move this to our old business agenda?
Second.
Motion made and seconded to move this as item 1 under our old business agenda. Is there any further discussion? Hearing none, all in favor say aye.
Aye.
Opposed? This matter will be item 1 under our old business for discussion and possible action agenda.
Thank you.
Okay. Item 2 under continuation of public hearings, Newtown Road LLC, Maria and Manuel Neves Govea Marquez and Antonio Mendez Govea Marquez. Application for special exception site plan approval for child daycare center in the CG20 RA8 zone, 36 Newtown Road, 40 and 42 Newtown Road, Whitney Avenue. I'll skip the reading of the map numbers, special exception 780. As I mentioned earlier, we received a letter from Attorney Marcus dated February 16, 2021. I won't bother reading the whole letter, but in it, he requests that the commission table the pending application for the maximum time allowable under the executive order, so he can he's going to go to the zoning commission and try to do what he said in his letter. So unless there's any objection, you want to, what's that?
Motion to table.
Motion made to table. Do I hear a second?
Second.
Motion made and seconded to table this matter till our next meeting. Is there any discussion? Hearing none, all in favor say aye.
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 Opposed? This matter is tabled. Thank you.
Thank you, Mr. Chairman. Thank you.
No problem. Okay, we will move to item 1 under old business for discussion and possible action, and we are right back to JAR Associates LLC, D&B Wellness LLC application for special exception revised site plan approval for a medical marijuana dispensing facility in the CA80 zone, 105 Mill Plain Road, C14063, special exception 779. Commission members, would anyone wish to comment or give guidance to Jennifer at this time?
I will.
Go ahead, Joel.
I think it's pretty straightforward at this point. I'm happy with the site plan as presented. And I would say, give it the usual terms and conditions for, compliance with all regulations, and give it a thumbs up.
Anyone else?
Mr. Chairman, I would concur with Mr. Urice's comments. I think
Thank
it's
you,
a
Mr.
good project, and definitely looking forward to seeing it move forward.
Great.
Ellen, same here. It is straightforward. We seem to have knocked down any objections that initially came up, so I'm for a go.
Okay.
Mr. Chairman, I'm in agreement. I'm in agreement as well.
As am I. Jen, you have your guidance.
Thank you very much.
You're welcome. Okay, we're going to move right to referrals. 8.3A referral petition of BRT Wisconsin LLC to amend section 4A6 of the zoning regulations, add active adult cluster development to the RA20 and RA40 zones. Public hearing scheduled for February 23rd, 2021. This date is subject to change depending on circumstances related to COVID. And commission members, staff had previously distributed information on this matter to you. I believe, Sharon, are you going to take the discussion on this one?
I am, yes.
Please.
Okay, thank you, Mr. Chairman. I'm Sharon Calitro, I'm the planning director. So the zoning commission received a petition to amend section 4A6 of the zoning regulations to permit cluster active adult development in the RA20 and RA40 zones. And the reasons given by the petitioner are included in the statement that's attached to the petition. It's a little misleading because they talk about it as an active adult residential floating zone, and it is not that. It's actually a petition to amend the existing regulations governing cluster development in the single family RA20 and 40 zones to allow a density bonus for the construction of a cluster active adult development. It also seeks to add 2 and 3 family dwelling units to the list of permitted uses in those zones under the cluster provision. If such units are age restricted, and it would require 10% of the units to be affordable pursuant to Connecticut General Statute Section 8-39A. There's a myriad of other conditions and requirements that are proposed. And as I had previously indicated in a staff report, placing an age restriction on a project or deed restricting units as affordable doesn't require any municipal approval. What does require an approval is to allow for Danbury to allow a density bonus to do that. I've provided some comments on the petition. I gave you a history of the petitioner's intent and interest in the petition to allow for this increased density for age-restricted housing. And some more detail was provided in the June 2020 report on a similar petition. I've attached it to the staff report, so I'm not going to go back all through that detail, but there's a lot of information in there that I've referred back to. Again, the petitioner owns property up off of Clapper Ridge Road that was approved back, I believe it was 2008, for 2 single family lots and a 12-unit single family cluster development. and they've indicated to staff that if this petition were approved, that they would seek to apply the regulation to this site. The petitioner claims that the creation of what they call a floating zone, although that's not what it is an example of smart growth, and that multifamily is fiscally superior to single-family projects. Again, I'm going to refer you to my comments on both those issues from the previous staff report. They've also indicated that they studied all the towns and cities in the region. I gave you a quote from the report, and almost everybody except Danbury has some kind of regulation that allows the density bonus for age-restricted housing in areas that allowed traditional single-family homes. It doesn't, however, the petitioner provide any documentation for that. We do note that in our discussions with them regarding this, they gave us some examples. And I have to say that when you look at and you do a deep dive into them, many of the density bonuses were provided for actually detached single-family dwellings in single-family zones. Again, the current petition not only would allow for an increase in density, but for the creation of single-family detached dwellings, but also for two-family and three-family dwellings. And as you know, two-family and three-family dwellings are not currently allowed in the RA20 or RA40 zoning district. I also made some comments relative to their claim that we should accommodate for demographic and cultural shifts in society. I think we do that. We have a multitude of housing options in Danbury, different densities, different price points, different configurations. Housing is allowed in more than one half of Danbury's 21 zoning districts, and there are several districts in which we currently allow a density bonus for affordable housing. We think that higher density is already permitted in areas where there is existing infrastructure to support it and where the principles of smart growth can be met, and there would not be a disruption in the existing zoning scheme. Again, the RA20 and RA40 are single-family zones, and multifamily units are not permitted in those zones. Again, we would suggest that the commission focus on whether the benefits of considering the density bonus for age-restricted housing outweigh what the potential changes to the neighborhood character could be, as well as the incompatibility of the proposed uses, should they be allowed to locate in traditional single-family neighborhoods. Maybe consideration should be given to more appropriate locations where the age cohort, where projects for this age cohort could be developed that really support the principles of smart growth. And even in a cluster design with a requirement for affordable housing, we just question whether this approach is just too broad and the implications too wide for Danbury. It's a good thing to increase the supply of affordable housing units, but this may not be the best way to do that. I've given you some specific comments on some proposed language. So again, the petition seeks to amend the 4A6 regulations, which is cluster development in the single-family zones. And cluster development, the intent, and I'll read you from the zoning regs, to promote environmental protections and to preserve and make available open space for recreation and conservation. So that's what the intended purpose is stated. And so this petition, I think, kind of intertwines that with the introduction of uses that aren't now permitted in that zone, with density increases, with age restrictions, with affordable housings, and they may all intertwine on a project, but I think we need to look at kind of our zoning scheme and whether this is the appropriate way to do it. The introduction of uses to the single-family zone and the increase in density for the cluster development is actually contrary to how the cluster regs read right now. As many of you know, and you've gone through the approval process, the cluster the way the cluster regulations are set up and the calculation was determined was not to allow for an increase in density. It was actually to maintain the existing density, but to take that density and shift it to a portion of the site so that you would preserve the other environmentally sensitive area or to preserve some recreation and open space. So right now, it does not permit a density bonus. And so it's interesting that why you would propose only a density bonus for active adult in a cluster and not anywhere else. And the same could be, for affordable housing. Why would you only require affordable housing in the cluster, in the active adult, and not in other scenarios? And as you know, we already have in the RMF4 and RMF6 zones, which is the housing incentive option, which does allow 2 and 3 family units and allows a density bonus for that. So we do have provisions, and that demonstrates it, that make accommodations for both increased density and affordable housing. In terms of the proposed changes in the use, again, we have some concerns under this petition to allow the way it's written, to allow 2 and 3 family dwellings in the single family zones. Under the section B on ownership, they've mixed some language in there relative to the to the federal statute under an ownership provision, which is a little slightly odd. And I think we need to use the correct term under the federal fair housing statute. It's housing for older persons. It's not, you won't find in the federal statute anywhere where it says active adults. And again, there is no provision in the amendment regarding the applicant's responsibility because we have some concerns about that becoming our responsibility. Well, the applicant before and then subsequent to ensure that the development, would be and remain in compliance with the federal statutes. It leads to a significant enforcement complication and issue, which is, as I indicated in the previous staff report, one of the reasons why I think Dennis and the zoning commission years back got rid of the age restriction or age restricted language that was in the zoning regulations. In terms of the lot size, the amendment to the lot size, so the proposal would be, so right now in the RA20 you need 5 acres and in the RA40 you need 10 acres to do a cluster. So the petition seeks to allow this active adult cluster with, of course, the affordable housing requirement on a parcel in the RA20 district that would then go to 10 acres, but maintains the RA40 at the same 10 acres. So, query, why wouldn't you increase the RA40 if you've increased the RA20? Like, why would more land not be required as the density increases as compared to the existing regulations? So you get more density on a smaller area of a lot without requiring, again, a bigger lot. Under the density calculation, the proposal is to not use the 20 or 40,000 in the calculation, but to reduce it to 15,000. So obviously there would be an increase in the number of units. And the requirement on the 10-acre minimum would garner probably 3 dwelling units as affordable. The proposed changes under language under the area and bulk is a little bit odd. Again, they called it a district AA. This isn't a district. It's not a floating zone. It's not a district. This is a cluster development. If it were to be approved, this would be a regulation under cluster development. So there's no new district and there's no new floating zone. And so I think, obviously that term would have to, is problematic. There's also, they're proposing to reduce the minimum horizontal building separation by 50%. So if you recall, if you go to the 4G3 standards, I think it's 4G3, the minimum building separation is 20 feet. So they want to go to 10 feet, but only under this scenario. So it's just a little bit odd why there's really no density or affordability justification to reduce the minimum building separation distance as compared to any other development of these kinds of units that we would require. So I don't see the reasoning for that. So again, 2 or more dwellings on a parcel, similar to the above, they want to be exempt from that requirement that that in the existing regs. And I think it's also, the petition is inconsistent with the zoning scheme in terms of the design standards. Again, not just the separation distance, but 4G3 has a whole bunch of design standards for 2s and 3s. And they're not applicable to the 1s in the single family zones, but they are applicable to the 2s and 3s in all the other zones. So the proposal is to be exempt from any of those. So why is that? Why would they be different? Why wouldn't you treat them the way you treat, if you're in an RMF4 zone and you can build 4 2-family dwellings and you have to comply with the design standards, why would those design standards not be applicable under a cluster development where you could build 4 2-family dwellings? There's really there's no justification for it not to apply. There are no proposed changes to the open space, sewer, water, or administrative review sections of the regs. And then they've added a section under the affordable housing. Again, the requirement is that 10% of the units would have to be affordable pursuant to section 8-39A. A lot of that, and I gave you some language on what that means. And then there's some additional language, which mirrors the language that's currently in the RMF 4 and 6 zones under the housing incentive option, that provides for affordable housing, except they want to be exempt from the section of the statutes which allows for that. So again, it's just a little bit odd. And the petition also notes that the last sentence of that section that they want to add alters when the affordable units have to be permitted and issued. So in the housing incentive option regulations, that allows you to increase the density and above there's a 1-for-1 balance. So 1-for-1 above what you normally could get, you have to provide 1 affordable unit for 1 market rate unit. So if your base density, as an example, were 10 and you allowed 10 additional units, 5 of those would have to be affordable, 5 would be market, and they have to be built kind of at the same time. So there's, you don't end up with, oh, I'll just build all the affordable at the end. And so the proposal under this petition is not to utilize that kind of process. And I think that's inconsistent. If you're going to allow it, you might as well do it the same way we do it and make sure that they're permitted and they're CO'd as the development proceeds. So you don't wait to the end for one reason or another that, potentially something may not happen. Then I wrote up a section on the consistency with the plan of development. And while the plan does provide that land use regulations should periodically be reviewed and amended to remain current, it's questionable whether this format is really responsive to our needs and is compatible with our development pattern. And I've gone through, I'm not going to go through them, you have it all, ways in which we feel this petition seems to be inconsistent with many of the goals and our policies and recommendations of the plan, not just in the land use section and in terms of protecting residential neighborhoods, but in the housing plan as well. And so finally, again, as with the previous petition, there may be some merit to this. There probably is merit to the provision of age-restricted housing. I'm not saying that Danbury doesn't need that. I'm saying we should be looking at this after we've studied our community. And we've done a proper study of the needs and based on the demographics of our community. And we are honestly undertaking that at the moment and statutorily required to prepare an affordable housing plan by next year as well. And so this may be, to look at age restricted housing, we may find that that's an appropriate thing and allow for it in zones where there are similar uses, where there are similar densities, and where they're in closer proximity to the services and the transit networks that support the older adults. And while, again, as a general rule, the zoning commission, and this is more related to the zoning commission, but for your benefit as well, the zoning commission could allow for increased density for 2s and 3s for age-restricted units in zones that allow single family. The question is whether this is the right petition to do that for Danbury. And based on our review of it and our noted concerns, we did not think this was the appropriate way to do it. So again, we thought there could be some unintended consequences throughout the entire city. We think it's important to look at the city as a whole and really do an analysis based on demographics, based on looking at affordability, based on demographics and looking at the age cohort and incomes and things like that. And we're concerned about the 2s and 3s, the introduction of 2s and 3s into more, into our stable residential neighborhoods. So with that, I will take any questions. Again, I gave you the report dated February 11th. I attached my previous one as backup to that.
Mr. Chairman?
Joel, go ahead.
That was a very eloquent summarization of the application, Ms. Calitro, and I appreciate it. But I'm kind of a simpler person, like an old country bookkeeper, kind of is my background. But aside from the implications of perhaps providing some more affordable housing in the town of Danbury, it would be, in effect, making all of the RA 20 and 40 single-family homes into multifamily zones. And we would, in essence, be telling all the people who have purchased over the years and paid their mortgages and to be in a single-family zone that tough luck. You might have at the end of your street what's been proposed as a cluster development, but it doesn't really meet the current cluster development guidelines that we have in the city. And it just doesn't seem right to the people that own property and own homes and been living in these single family zones for in many cases decades, that we're going to change your way of life. And we have multifamily zones that these same kinds of structures that are being proposed for this requested zoning change can be done, although they would have to adhere to the little more stringent requirements in those multifamily zones than what's being proposed here. So I just can't see any justification is it right to do to the city's citizens of this town? I just don't see the justification for changing so many people's way of lives potentially, because you could create 10-acre plots by buying up enough little houses in one area, and boom, you've got 10 acres to do one of these in. I just on the surface of it, it's not right to the people that live in these zones. It doesn't really do what it's proposing to do. It doesn't have the same restrictions even where we do have cluster developments. And multifamilies are not cluster developments. As you say, the whole purpose of the multifamily or the cluster develop is to take and preserve larger pieces of nature in the neighborhood, not increase the density of the neighborhood. So my reaction to this is no. I can't recommend this in the city of Danbury. I would have to take a position of a negative referral, and unless somebody can convince me differently here in the next little bit.
Thank you, Joel. Thank you for your comments. Appreciate that. Would anyone else like to comment at this time? Anyone else have any thoughts? Helen, please.
Unmute. So first of all, I'm going to agree with Joel. First of all, before that, I want to thank Sharon for a great report. I was going to talk about the report, but it was very, very detailed, a great detailed analysis, which again, you did comment here on much of that. So thank you very much. As we just heard, and what I believe is that there's a lot of confusion around this application. And as Sharon mentioned, that would easily cause unintended consequences in our residential neighborhoods. The POCD doesn't support this at this point. There's numerous references to having this kind of thing done in urban core and urban development areas, but not in our single family home zones. We also, the POCD says that it wants to limit development in suburban areas to low density residential neighborhoods. So the POCD, that's one of our tenets, is we have to make sure that our applications are aligned with POCD. Other zones presently, it's been brought up again by Sharon, other zones address the needs that are in this application. There's benefits to the way it exists right now in terms of getting around. Transportation is supported for this in the higher density zones and not in the residential neighborhoods as much. Affordable housing plans and Danbury's needs for housing. Sharon just mentioned too that we have to do a plan and get an analysis done of what the needs are for Danbury. So in a sense, this is very premature to understanding all that, and Sharon did point that out as well. So for all those reasons, I don't think it's the right time to approve this application.
Thanks, Helen. Thank you. Any other members of the commission want to weigh in? Hearing none, I'll just say, well, first of all, again, Sharon, I don't want to repeat everything anybody else said, but a lot of hard work on that report. Thank you. The June 20 report was 9 pages, and this more recent one was 5 pages. So you've got 14 pages of single spaced reports on this matter, and it's very thorough. So well done on that. Thank you. Again, I agree with the comments made by Joel and Helen. I will try not to repeat things my predecessors said, but the first thing we typically do, as Helen mentioned, is we check compatibility with the plan of conservation and development. Unfortunately, this particular matter is not compatible with the POCD, which says, again, repeating slightly what Helen said, we should concentrate future a medium and high density residential development in the urban core and urban development area. Now, with that said, as Sharon mentioned, we are currently drafting a new POCD. In fact, we had an oversight committee meeting yesterday. And the matter of housing is very important. And as Sharon said, we'll be looking at that comprehensively for the whole city as part of the oversight committee. And she also mentioned that we have to submit an affordable housing plan next year by statute. So this is a matter near and dear to our hearts, and that's being looked at comprehensively and thoroughly. And as I think Helen mentioned, this particular application might be premature. Let's do the study first. And as Joel mentioned, I think Joel's comments boil down to concerns over the injection of multifamily development, cluster development into traditional single-family zones, RA20 and RA40, which have the potential to change the characteristics of the traditional single-family areas and have unintended consequences, something we should be very concerned about. And that includes 2 and 3 family houses, by the way. And then there's some other things Sharon mentioned. Again, her report is so thorough, I won't even attempt to recite or prioritize the various objections she had. There's really no way to guarantee that the seniors that live in Danbury would take advantage of this opportunity. And actually no meaningful data to suggest that it will help keep seniors in Danbury. I mean, we know that a lot of seniors move out. The decision on where to move, particularly for a senior on a fixed income, is a combination of many different factors. I mean, a lot of people move south. That has nothing to do with zoning. They like the lower taxes down there or the weather. So it's not any sort of guarantee that it will help us retain seniors in this area. And then the idea of smart growth, which is great, but it's not just a matter of density, as pointed out in Sharon's report. It's more comprehensive than that. And one of the things smart growth encourages is transportation options to mitigate the environmental impact of costs of an auto-dependent development. And the farther you move from your urban core, or the more potential there is for an auto-only development. You can't have other modes of transportation out in the suburbs. So again, for those reasons and for the reasons stated and the reasons shown in Sharon's report, I agree with Joel and Helen. I'm not comfortable at this time with this particular zoning amendment. Anyone else? All right, if there's no other discussion, I'll entertain a motion if someone would like to make it. Remember, this is a referral. We'll be making a motion for either a net positive or negative referral.
A motion to issue a negative referral back to the zoning commission.
I'll second that.
Motion made and seconded for a negative referral. Is there any further discussion, commission members? Okay. so
Again,
remember-
Mr. Chairman, again, let me just, I'm assuming for all the reasons that you've stated, now that
Yes.
the motion is on the floor.
Yes,
Thank you.
So amended.
right. Joel's reasons for all the content of your 2 letters. Make sure you say that, Joel, and the other items discussed this evening. Okay. A yes vote is for a negative referral. A no vote is not for a negative referral. And on this one, we're going to take a roll call vote. Mr. Urice,
Yes.
Ms. Hofstadter,
Yes,
Mr. Kyokyo,
Yes, yes.
Mr. Sylvain,
Yes.
Chairman Finaldi votes yes. This matter will get a negative referral. Okay, we'll keep moving. The other items on our agenda are the new business items. You can take a look at those. There's nothing under correspondence or other matters. Unless there's anything else, staff or commission members, I will entertain a motion to adjourn.
So
Anyone?
I'll make a motion to adjourn.
I think Neil Marcus made that motion. Okay, a motion made to adjourn is our second.
all right, I'll second.
All right, motion made and seconded. We're gonna take a voice vote. All in favor, say aye.
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 The meeting is adjourned.